The enforcement part is designed to make you take care that you're doing the right thing when you're doing the work. They're casting a wider net to ensure everyone is doing their part in protecting the public and the habitat for humanity. Hello and welcome to the fourth episode of our podcast. I'm Kouchoo, here to guide you through the ongoing changes reshaping the building and construction industry in New South Wales. Today, in this fourth episode, we'll touch on inspection and enforcement, preparing for the Building Commissioner's powers. We'll look at the way in which the industry will be monitored, the enforcement mechanisms that will come into play, and how this will affect the building industry as a whole. Thank you for tuning in. This episode is particularly important because it covers oversight mechanisms that you, as a professional business owner, need to be aware of. In the first episode, we canvass the why behind these changes in the industry. In the second episode, we examine some of the proposed licensing changes. In the third episode, we put it all together with a focus on the duty of care and the Pathburn case. This episode builds on the first three, highlighting how enforcement is to be integrated into a more broader, more systematic way of doing things. The changes are mainly to be enacted in draft, building compliance, and enforcement. It's about the issue of public confidence in the building space and what the High Court calls collective responsibility, which is basically said to be everybody's business. The enforcement part is designed to essentially make you take care that you're doing the right thing when you're doing the work. As mentioned before, they're casting a wider net to ensure everyone is doing their part in protecting the public and the habitat for humanity. What does it mean for you? Well, there are many changes, and I'll quickly go through these. First, there's the regulatory purpose. The Building Commissioner is taking a strong stance to eliminate industry misconduct by targeting non-compliant practitioners, referred to as bad actors, and by restoring trust in construction standards across New South Wales. Second, there's the expanded legislative authority. The Commission will be vested with prescribed enforcement powers under a consolidated legislative framework, including Security of Payments Act, Building Bill, Building Insurance Bill, Gas and Electricity Act, and others. This integration ensures a more cohesive and consistent enforcement regime across the sector. Third, there's the wider enforcement network. Authority will not just be limited to the Commission. Enforcement powers will also be conferred on local councils, the Architects Registration Board, accredited certifiers, and others. These entities will have the ability to issue enforcement directions, with council authorized to back these directions through formal legal instruments such as council orders. Fourth, there's the graduated compliance strategy. The compliance model begins with education and cooperation, but escalates where necessary. Initial measures, warnings, and enforceable undertakings will be escalated to penalties, remedial orders, prohibition orders, and exclusion provisions. These will include the activation of an excluded persons register, which is very important. Fifth, there's the focus on serious defects. Enforcement will prioritize serious defects, defective work that causes or is likely to cause substantial harm, structural failure, or safety risks. Six, there's the unrestricted investigative powers. Authorized officers will have the power to enter construction sites and strata, common property areas without a warrant. Investigation costs may be recovered from the party found to be at fault, reinforcing the principle of accountability and non-compliance. Seventh, information disclosure and self-incrimination. Body corporate representatives are required to provide information, even when it may be self-incriminating, Such information is admissible in both civil and criminal proceedings. The privilege against self-incrimination does not apply under this framework. 8. There's the immediate and preventative orders. Regulators will have broad powers to act quickly, issue on-the-spot remedial directions, especially for specialist or high-risk work. They can impose rectification orders and stop work orders, which may apply across the entire industry in situations involving widespread risk. Enforcement prohibition orders to prevent occupation of unsafe premises will also be available. 9th, there's going to be the procedural fairness aspect of this. Procedural fairness will apply in most cases, with affected parties given an opportunity to respond before enforcement action is finalized. But in emergency situations or where stop work orders are required, action may be taken without any prior consultation. 10th, there's the streamlined disciplinary framework. Disciplinary action will be governed by a centralized, uniform process. Powers will include immediate suspension where public safety is at risk. Show cause notices may be preceded by disciplinary outcomes, with practitioners potentially being listed on a public register of enforcement actions. You need to approach all these matters with caution. And when you're entangled in this net of compliance and enforcement, you will need advice, because most lay people won't even understand what issues related, for example, to self-incrimination actually mean. But there's more. As I have said, prevention is cure. It's better to prevent these problems, but if you find yourself facing an enforcement issue like a stop work order, you need expert advice to navigate that dangerous terrain. Before we wrap up, I'll just remind you that in our next episode, episode 5, we'll take a close look at the future of construction law, preparing for ongoing reforms. We'll be putting together everything that we've discussed so far and reviewing how you can always stay ahead of the game. To help you better understand these changes, Kreisson has compiled a comprehensive suite of resources, including in-depth ebooks, which analyze the legal implications, and discussion papers and articles offering detailed commentary. Thank you for joining me for this 4th episode. As always, if you have questions or need advice about any of these changes or about your business generally, the team here at Kreisson is here to help. Don't forget to subscribe so you don't miss what's coming. Till the next episode, stay informed and stay ahead.